Thomas A. Lenz is a partner with Atkinson, Andelson, Loya, Rude, and Romo, AALRR, a full-service law firm with over 200 attorneys in 9 offices throughout California. AALRR represents both private and public sector clients with emphasis in the areas of employment, labor, construction, education, real estate, water, general business and business litigation, corporate, and taxation. Mr. Lenz works out of the firm's Pasadena office. Since he joined AALRR in 1992, he has handled a vast array of complex labor and employment matters, often on the cutting edge of developing legal issues in a variety of industries. He handles all aspects of labor and employment law issues and heads the firm's traditional labor and National Labor Relations Board practices and works with employers in all major industries across California and the West. Mr. Lenz served as chair of the Labor and Employment section for the California Lawyers Association, formerly the State Bar of California, during the 2017 to 2018 term. He serves as an adjunct lecturer teaching at the USC Gould School of Law. He is frequently consulted by the media on workplace issues. Information on his media activity and articles he has written appear on the firm's website, www.aalrr.com. Mr. Lenz may be contacted at tlenz@aalrr.com or 626-583-8600.
Hello, I'm Tom Lenz. I'm a partner with the law firm Atkinson, Andelson, Loya, Rude, and Romo, based in Pasadena, California. I handle labor and employment law cases, and I'm here today to talk about the National Labor Relations Board. This is a National Labor Relations Board update from the current time, March 2023. And you see my firm's website right there, www.aalrr.com. And I have contact information at the end as well. We will be talking about several areas of development involving the National Labor Relations Board and the federal law known as the National Labor Relations Act, which that agency enforces. There are case rulings we will cover. There is new information involving remedies for violations of the National Labor Relations Act. We will be talking about regulations, which the National Labor Relations Board considers from time to time to address issues and procedures under the National Labor Relations Board and its proceedings. And there is also information on legislation, because the topic of labor law reform is one which pops up from time to time, and there are proposals which are out there right now. Now, before I get into the cases, I should mention that the National Labor Relations Board was created in the 1930s to enforce the National Labor Relations Act, a federal law which gives employees certain rights under Section 7 to form and join labor unions, as well as to engage in other sorts of concerted activity, which may deal with wages, hours, or working conditions. Such group activity is often viewed in a lens of being for mutual aid or protection, and even without a union may have protection of the law. And the National Labor Relations Board investigates and prosecutes cases of unfair labor practice allegations, and they will also hold elections when requested on whether or not a union represents a group or unit of employees. So these are the types of cases which come before the board and where there are developments at issue, which we'll talk about today. So there's been a lot of rulings, especially in recent months, and we are expecting more rulings to come, because the Labor Board has a very active agenda in not only handling the cases that come before it, but in looking at possible changes to legal standards, which come about frequently through the cases. So we'll talk about some of the most important rulings, certainly not all of them, given that hundreds, if not thousands of cases are filed in a matter of months or certainly in a year. You can see further developments on these and other NLRB issues and developments at the NLRB's website, which is www.nlrb.gov. That is a very informative website. It is updated regularly, and when there are new rulings or guidance memoranda or press releases, things of that nature, they usually pop up promptly on that website, and you can also sign up for updates via email, which can be very helpful if you practice in this area. The first case we're going to talk about is American Steel Construction. This is a board ruling from December of 2022, which came about in an election case scenario. So a case about whether a union would represent a group of employees. And the issue here was the bargaining unit determination. In other words, which group of employees would be able to vote in an election. And the employer often will disagree with the grouping that a union chooses and puts forth for an election. And in this instance, very typically, the employer disagreed with the union's proposed grouping. The union sought to represent some, but not all, of the employer's job classifications. And in this case, the National Labor Relations Board panel, which is a 5-seat panel currently filled by 4 people, appointed by the president, confirmed by the Senate. The panel reinstated analysis that had come about during the Obama board some time ago. And they basically removed a standard that had been put in place by the Trump board. You'll see that the NLRB tends to be a somewhat political agency, depending upon which party is in power in the White House. And you'll see that in terms of their appointments and the policies that are pursued. In the American Steel case, the board said a petition for unit, in other words, the grouping requested by the union, must be readily identifiable as a group and share a community of interest. However, where a party argues that a proposed unit meeting these criteria must include additional employees, in other words, what the employer is trying to do to add employees to the voting group, the board reaffirmed that the burden is on that party to show that the excluded employees share an overwhelming community of interest to mandate their inclusion in the bargaining unit. So if you represent employers, you are going to have a high bar to cross in order to convince NLRB to add additional employees to the voting group. If you represent labor unions, you are certainly going to want to hold the employer to that high bar, and unless you find it strategically or otherwise desirable to agree to what they seek, you have a strong legal argument based upon this new authority that the employer cannot just demand and get an addition to the voting unit requested. The next case I'm going to talk about is RMAS Products. That is also a December 2022 ruling of the National Labor Relations Board. And this one is an unfair labor practice case involving a claim that an employer failed to bargain in a lawful way with the union representing its employees. And this came in the wake of an NLRB election, and the employer was refusing to acknowledge that a valid election had happened. And they used the NLRB process to do what practitioners refer to as testing certification. In other words, saying, we are not going to bargain with this union because we don't think there was a valid election. And often through those sorts of proceedings, the employer will take the posture that we will probably lose at NLRB and go into the federal courts of appeal to test the NLRB ruling and thereby test the election. Well, what NLRB's board did, the board panel in this case, it was to tell the employer, look, you lose, you did not bargain in good faith, so you violated the law, and we are going to give the union an extra year of protection, irrebuttable presumption of majority status, so that the union could not be removed as the employee's representative, and also force that employer to the bargaining table for an additional year of negotiations. So the employer could not just necessarily walk away. And additionally, the board, as a remedy for this bad faith bargaining finding, ordered the employer to compensate the union for delay in the bargaining process. In other words, this was a type of compensatory damage that the union would be able to claim. So employers that are in a position of disputing an election or saying that even though a union won, they were not going to respect that result, should pay close attention to this, because there is a potential monetary liability in addition to simply being found in violation of the duty to bargain and having committed a technical unfair labor practice. So the board is adding teeth, and unions will certainly be paying attention to this in order to try to protect a newly unionized group of workers. The next case I'm going to cover is a very important one for employers who perhaps have multiple shifts, or maybe multiple different businesses working in the same location, and people seeking access after hours. This case is called Bexar Performing Arts Center. It too was a December 2022 ruling. That was a very busy month at the NLRB. This case arose in Texas, which is not a union-heavy state, but certainly with the NLRB protecting not only union conduct, but conduct involving employees, group activities, and things done for mutual aid and protection. Issues arise there too. And what happened in the Bexar Performing Arts Center case was that an off-duty employee sought access to the workplace, and the employer was found to have unlawfully barred San Antonio Symphony employees who regularly worked on the property from accessing the property to engage in protected protest activity. So even though the off-duty employees were symphony employees, and it was the Performing Arts Center, not the symphony, that barred these off-duty individuals from coming onto the premises, it was viewed to be chilling and unlawfully restrictive on employees' Section 7 rights to engage in protest activity regarding their wages, hours, and working conditions. This is another case where the Biden NLRB board reinstated a standard from the Obama years and looked beyond a legal standard from the Trump years. So again, the political nature of NLRB and the flip-flopping of some legal standards is certainly visible here. And what the board panel said in this ruling is a property owner may lawfully exclude from its property off-duty employees who regularly work on the property for an on-site contractor and who seek to engage in protected activity only where the property owner shows the protected activity significantly interferes with the use of the property, or where exclusion is justified by another legitimate business reason, including but not limited to the need to maintain production and discipline. So this is a message to unions and employees that you've got the right, even off duty, to come on premises unless the employer proves, that there's really some significant interest to be protected. So employers who believe they've got a blanket prohibition on off-duty people coming back onto the premises, you better reassess your policies. You better have a look at this, because the NLRB will consider otherwise. And even in the absence of a proven victim, the NLRB has not been shy about declaring policies themselves to be unlawful and to have inappropriate chilling effects on employee rights. The next case I'm going to cover is called Grill Concepts. Once again, a December 2022 ruling of the NLRB panel. And in this case, it is another refusal to bargain situation where the employer has a bargaining relationship with a labor union and is not, in the union's view, bargaining lawfully. These cases involving bargaining can be extremely detail intensive, and oftentimes practitioners are having to look at bargaining notes and proposals and the day-to-day, hour-to-hour progress of negotiations to determine whether there was good faith or bad faith in the process. Now, there is no duty under the law to agree, but you need to show movement. You need to show you consider the other side's position, provide relevant information to consider proposals, etc. So the Labor Board looked at the details of how bargaining progressed, and they saw that things were not happening with sufficient speed. It was slow progress and delay in the NLRB panel's view. And this is another case where the board added teeth to the remedies. So rather than simply ordering the employer to bargain in good faith, rather than issuing an order just saying that, hey, employer, you need to do this, do that, you need to meet and bargain in good faith, the NLRB added teeth by ordering that the employer pay the union's bargaining expenses. So this is certainly a reach into the pocketbook moment. This is something that will cost the employer above and beyond whatever they're paying their representative to negotiate. So this is something that the NLRB is hoping employers will take more seriously when they bargain, that whether agreement is reached or not, that good faith should be used. And if you do not do things appropriately, you could be on the hook for unions' expenses. So I expect that unions will be holding this over employers' heads if bargaining does not meet their satisfaction in terms of speed and progress. And unions would be wise to maintain an accurate accounting of what it's costing them to negotiate. And given the change and aggressive posture NLRB is currently taking toward remedies, this is something that an employer should be mindful of in going into bargaining. One of the new NLRB rulings that has been generating a lot of discussion is the McLaren-McComb case. This came out in February of 2023. It's hot off the press, and this is a case which deals with severance agreements and the sorts of waivers of labor law rights that appear in severance agreements. Now, you may think that, well, under state law, California, for example, has rules on what you can allow, what you can't allow, and more and more in the last 10 to 15 years, especially, we've seen NLRB taking positions and establishing legal standards which either run consistent with or perhaps complement the standards under California law. For example, sometimes California will, go beyond what the NLRB does in terms of regulating certain things. But I mean, certainly private sector labor law is mostly a federal thing, but it's interesting when the labor law interpretation extends into things that people might have historically, traditionally considered HR and in the state law realm. So McLaren-McComb is one of those cases, and the board reversed course on the rules for waivers of labor law rights in this severance agreement context. And a couple of things that really caught the board's attention were non-disclosure and non-disparagement clauses. In other words, non-disclosure, you're not going to be talking about things that happened at work. You're not going to be telling people about issues or disputes that arose. You're not going to be raising issues about, why you had a particular problem in your job leading to your departure, etc. So Nlrb takes issue with that because in their view, Section 7 rights include the ability to talk about your wages, your hours, your working conditions. And if you can't talk about things that that you view as problems, that is chilling the rights of employees under federal law. So non-disclosure clauses, item 1. Non-disparagement clauses, item 2. This is one which is very controversial. Many employers seek severance agreements and other types of agreements and policies where employees don't badmouth the company. You're not going to say that somebody was a bad boss. You're not going to say that you suffered discrimination. You're not going to say that you were treated terribly, or this company is, not a good place to work, etc. So employers often want that because they don't want people to resolve a case, get a payment to resolve the case, and then say terrible things about the company. But again, NLRB's view of Section 7 rights is one where employees have the right to talk, and they have the right to engage in group activity. So whether you resolve something or not, NLRB took issue with non-disclosure and non-disparagement clauses. So in their view at NLRB, former employees remain employees under labor law. There is a definition of employee in the National Labor Relations Act, and you might be an employee of a particular company, or you might not because your employment ended, or maybe you were an applicant but you weren't hired. But regardless, you are viewed as an employee under labor law. And giving up your rights under Section 7 as a condition of relinquishing your job is viewed by NLRB to be a problem. So in this case, the employer overreached with non-disclosure and non-disparagement clauses in their severance agreements, and that was an unfair labor practice. So it's important that whichever side of the equation you're on in assessing these legal issues, representing employers or unions or employees, we need to keep federal law in mind. Even if you operate mostly in state court, if you operate under the view that state law controls these issues traditionally, NLRB has something to say. Now, depending on who is president and who they appoint to the board, 4 years from now, that could be a different standard and different people enforcing it. But for right now, these are issues that NLRB considers in terms of potential violations of employees' rights under federal law and potential unfair labor practices by employers. I'm going to move on to a case called RAV Truck. This is another December 2022 NLRB ruling. They were prolific. They were busy at the end of last year. Another refusal to bargain case where the employer and the union were having some disputes over bargaining, and the matter went to the NLRB based on an unfair labor practice charge, and the employer closed part of its operation, and the union objected, saying, hey, look, you did not give us adequate notice. You did not give us an opportunity to bargain. And This is an important issue under the labor law because certain business decisions are viewed as impacting employees. And an employer may say, hey, look, we're the entrepreneurs, we're the ones taking the risk of running the business. We have the right to decide whether or not to open, close, move, etc. But when employees are represented by a union, the union takes the view oftentimes, you have a duty to tell us, you have a duty to give us information about what you're planning to do so that we can adequately represent and protect the employees. And unions are often thinking, because the law supports this, they have a duty of fair representation toward the employees they represent. And if they do not inquire, if they do not make demands, they might be in violation of their duties to the employees they represent. So the employer took action without, in the union's view, adequate notice. Were bargaining with the union before acting, and the labor board took issue with this as well. The employer was viewed to have violated the law. Now, in some instances where a business closes or relocates, the NLRB has actually ordered the employer to reestablish its business. In other words, okay, you may have closed, but you did it wrong, employer. You should have bargained. You should have provided notice. You didn't do that. We are going to force you to reestablish your operation to protect the jobs of the employees affected. In this instance, NLRB did not do that. Sometimes they would order that through their administrative proceedings involving the board. And side note that when these cases go to trial, it's before an administrative law judge. They are then reviewed by the 5-seat NLRB board. Again, 4 members on that 5-seat board right now. Those are administrative proceedings that can go into federal court. Some of these situations are viewed to be so serious and urgent that NLRB will go into federal district court to get an injunction under Section 10J of the National Labor Relations Act. Now, in order to get that injunction, you need to show the sort of traditional equitable factors and things like irreparable harm. And usually the courts want you to act quickly if you're seeking an injunction. Now you'll notice on the last bullet point here, there were 4 years that passed since the closure. NLRB was not, according to the board ruling, seeking a 10J injunction, not that the board had authority to give one. That would be for a district court. But because the board acknowledged there were 4 years passed since the closure, NLRB said it would be too long delayed and inappropriate to order reestablishment of the closed operations in this case. So details matter, the specifics of the case matter. The employer was able to take this action, close this facility without the reestablishment remedy that might have occurred if NLRB had ostensibly acted sooner. So this is an important one to be mindful of, that potential reestablishment remedy. And again, reminder to employers that if you're going to be doing something that's going to affect that bargaining unit, some big business decision, closure, relocation, etc., notify the union and offer to bargain before you act, because it could be undone in the name of a make-whole remedy and protecting employee rights. Sunbelt Rentals is the next case, December 2022, once again. This is a workplace investigation issue, and you may say, workplace investigations, this doesn't involve unions, this doesn't involve things that are labor law oriented, but actually it does, because the NLRB for many years has followed a legal standard that came from a case called Johnny's Poultry. Johnny's Poultry is something that longtime labor lawyers refer to when it comes to talking to witnesses. and getting information to determine whether they have knowledge of things that may impact an investigation on a particular issue. The employer, under the Johnny's Poultry standards, typically needs to provide an employee witness with assurances about their rights under the National Labor Relations Act and whether or not they participate in an investigative interview. There will be no retaliation and no reward either. It's up to the employee to decide whether or not to participate in that interview. Now, I should distinguish that this involves employee witnesses, not supervisors. Supervisors and managers, if you represent employers, they do not have these same rights. The same assurances are not required. But if you're talking to non-supervisor, non-management witnesses, these Johnny Poultry standard have been required for years. And in this Sunbelt ruling, the NLRB panel reaffirmed the importance and support of the Johnny's Poultry standards to protect employees in the context of a workplace investigation. So if an employer were hypothetically to talk to employees to ask them about something potentially impacting union activity, potentially involving things that might be viewed as intrusive on employees' Section 7 rights, without the Johnny's Poultry assurances, that employer's questions, that inquiry would violate the National Labor Relations Act. It would be an unfair labor practice simply to ask those questions without the assurances. The next case is T-Mobile. And this one is important because it goes to the question of what are employees allowed to do on an employer's email communication system, and what level of control can an employer have to limit or restrict communications. Now, this is another one of those political football issues, depending upon who is in control at the White House and who they are appointing to the NLRB. We are seeing different standards. In the Obama years, we saw a case called Purple Communications, which opened the law quite a bit for employees to use email and information systems for personal communication. Prior to that, there was a case called Register Guard, where the employer was given a lot of leeway to restrict what employees could say. In the T-Mobile case from 2022, the employee involved sent a mass email to customer service representatives, encouraging them to get involved with the union, to attend an event. T-Mobile disciplined the employee for violating its policies. And the NLRB ruled that T-Mobile violated the law by selectively and disparately enforcing its policies against the employee due to that union-related email, and for responding to the employee's email by establishing rules. You know, if you're aware of protected activity and then you start creating and implementing rules in response to that, that's considered to be pretty much on its face motivated by protected union activity and an unlawful change. And when you tell the employee that you cannot send union-related email to coworkers, even though you allow employees to send other sorts of non-work related messages, that is a sort of internal discrimination on personal activity communications. If you allow some, you often are required to allow others, even if you perhaps don't like that content. So I think inherent in these issues is If an employer claims to restrict and control what employees are sending or allowed to send, how consistently do they really enforce that? That's going to be a big question when you have situations like this, policies at issue. Are the policies written neutrally? Are they consistently enforced? So these are going to be important issues, and this is going to be a trap for a lot of employers who, again, perhaps may not be aware that labor law addresses communication in the workplace, and it addresses use of the systems the employer puts into effect. It could be email, it could be texting, it could be an intranet, but if you were trying to segregate out certain types of communications, and you touch upon employees discussing their working conditions or union activity, you need to address that sensitively because of rulings such as T-Mobile. The next case I'm going to talk about is from August of 2022, and it involves Tesla. And this deals with a hot topic involving dress code rules and whether employees can wear things that an employer doesn't like, perhaps wearing union insignia or some other insignia on their clothing, or while they're at work. There was a Trump era ruling in the Walmart stores case, which gave employers greater control over what they could do to restrict employees wearing things in the front of the store versus in the back of the store. And in this case, however, the Biden Nlrb panel determined that the employer's team wear policy was perhaps overreaching and violated the law. And by requiring certain things, it was infringing upon employees' ability to wear union shirts and union insignia. So the labor board took the view that the employer's dress code, in being overly controlling, was presumptively unlawful. And in assessing it that way, the board considered, were there special circumstances that the employer was able to raise, to establish, that might justify the policy? And the board did not find that there were sufficient special circumstances to allow the employer to have such a policy and to limit what employees could wear. So we regularly, with our management clients, will recommend that they review and modify policies consistent with developments in the law. And this is one of the areas, in addition to changes in the law that come up, state law, federal law, whatever it might be, this is one of those things where you need to make sure that you are up to date with your policies. Get them reviewed and check them carefully so that you are going to respect employees' Section 7 rights, in addition to whatever other laws may apply. The Thrive case is another 2022 ruling, and this is of huge importance to labor law practitioners. For decades, the National Labor Relations Board has talked about when there's an unfair labor practice, victims of the unfair labor practice may be entitled to remedies. Those remedies are not fines or penalties, they are make-whole remedies. In other words, restorative to put a victimized party back in the position they would be in but for the unfair labor practice. Now, the current general counsel of the National Labor Relations Board, a longtime Nlrb staff attorney, and who also did some work with a major labor union, when she was appointed and confirmed, she began to issue some guidance on developments in remedies and things that she wanted the agency to pursue. One of those being an expansion of available damage remedies. And Thrive is a case which goes to that point. You have a marketing agency that sold advertising, and the company was looking at layoffs, and these employees to be laid off were union represented. So the union, the International Brotherhood of Electrical Workers, requested an opportunity to bargain the layoff decision, and they requested information. And the company laid off the employees before reaching agreement and did not respond to the union's information requests. Now, requests for information, I hinted at it before, they are related to that duty to bargain in good faith. So the board in this case ruled that the employer violated Section 8A5. That is the bad faith bargaining standard. So it's not even a discrimination or wrongful termination standard. But the board ruled that the employer unlawfully failed and refused to respond to information requests and unilaterally, in other words, without reaching agreement, laid off 6 employees during a labor agreement. So the board looked at the remedies to be provided and determined that a make-whole remedy, a restorative remedy, included at minimum direct or foreseeable pecuniary harms that are a consequence of the employer's unfair labor practices. So in addition to the loss of earnings and benefits, the victims of unfair labor practices may incur significant financial costs, such as out-of-pocket medical expenses, credit card debt, or other costs that are a direct or foreseeable result of the unfair labor practice. It used to be the case that NLRB would look at, okay, you were out of work for 6 months, and how much did you make during that period? What was the employer paying somebody else to do your job? Okay, that's how much you're owed, perhaps minus what you earned somewhere else. That calculus is changing as a result of the Thrive ruling and as a result of the policies that the current general counsel is pursuing. And remember, this is a bargaining case, not a discrimination case, but still creative and expansive remedies coming into play. So if you are representing someone who is allegedly a victim of an unfair labor practice, don't just look at the loss of wages. Perhaps look at the benefits. Look at other losses attributable to that unlawful occurrence. And if you're an employer and you don't like this, I mean, you may be in a position where perhaps you're more inclined to litigate than you might have been. It might have been easier to settle before the current administration. But keep in mind that the NLRB is going to be aggressively looking for ways to expand make-whole remedies, which in their view and the view of many labor advocates will help to provide a more realistic remedy when people suffer harm as a result of labor-related issues. The next case I'm going to talk about is the Troutbrook Company case, December 22 ruling, refusal to bargain. And this involves a situation that frequently comes up when employers and unions go to the bargaining table. Many times one party or the other will say, before we talk about benefits and wages, the dollars and cents items, let's get everything else resolved and off the table. Well, the board said in this case it was inappropriate to delay and to condition bargaining on the economic side of things until the other non-economic issues were resolved. So remember, if you're in bargaining, don't try to hold issues hostage. It's important to keep the full gamut of issues out there and available for discussion. The next case, also 2022, is Valley Hospital. This is an issue that for unionized employers and the unions that represent the employees can be important because often in California and in a number of other states, when there is a union agreement in place, the employees working under that agreement must pay union dues, whether or not they are members. And they don't have to be members, but they have to pay dues or the equivalent of dues to the union because the union represents them for bargaining and disciplinary proceedings and other things. Now, other states, Nevada, Arizona, about half the states in the country are called right to work states, where employees cannot be compelled to pay dues. And in the public sector as well, employees cannot be compelled to pay dues because of a Supreme Court ruling in a case called Janus, Janus. But in the Valley Hospital case, where the NLRB is looking at that scenario where an employer is under a duty to collect and remit to the union the employees' union dues, and the employees can lawfully be required to pay dues. The employer, in this case, tried to cease deducting and remitting the dues to employees, or I'm sorry, to the union. And it's been, one of these flip-flop issues, depending on who is in power, whether an employer could cease deducting the dues and remitting those to the union when a labor agreement expires. Now, according to the board in Valley Hospital, dues checkoff is like other terms and conditions of employment and cannot be changed unilaterally after expiration of a collective bargaining agreement. And this is a retroactive ruling. So what does this mean? If you are an employer and you operate in a state where it is lawful to deduct the union dues, you need to keep doing it, just like you need to continue honoring the rest of your labor agreement. And you continue doing that until you either reach a new agreement or you reach a valid impasse in your negotiations, a very detail-oriented question. So this is something that certainly unions are happy about because they don't want to chase down individual employees to collect dues. There are some wrinkles in this issue. If you're in the construction industry, or your contract may end your relationship, and that circumstance may allow you to cease deducting and remitting. But again, details matter, so check this carefully. But the board is protecting labor unions with this ruling and enabling them to continue to receive the dues stream to which they were accustomed during the term of the agreement. Here is a DC Circuit ruling from January 2023, which is important. AFL-CIO versus NLRB. The Trump administration tried to change certain regulations involving the election process, and some of the legal challenges were successful. So NLRB is currently grappling with this. They're issuing press releases and things talking about how they are planning to deal with the outcome of this ruling. So if you are aware of those changes to the procedure, I'm not going to drill down deep into those. Just be mindful that not everything took effect, and the NLRB is still sorting this out in terms of how this affects the election process. You may recall that when President Biden was inaugurated, one of the very first things he did after taking office was to terminate the National Labor Relations Board's general counsel, who had been confirmed by the Senate previously, and a new general counsel was thereafter appointed, who is now in office. And some parties took that as a opportunity to defend against unfair labor practice cases, saying that the president acted inappropriately, in terminating that general counsel, and therefore whoever was signing pleadings on behalf of the general counsel in the various field offices was doing so without valid authority. That issue went before the Ninth Circuit in the NLRB versus ACASH case, January 2023 ruling. And this was another refusal to bargain case, and the Ninth Circuit enforced a National Labor Relations Board order, and the Ninth Circuit ruled that the president acted appropriately in removing General Counsel Peter Robb before the end of his term, because there were no stated limits to the president's discretionary power of removal. The employer also took issue with the bargaining unit, and the court did not find basis for that. But NLRB's current general counsel, Jennifer Abruzzo, her authority to move forward on these cases after Peter Robb's termination was basically validated by the Ninth Circuit. And as you might imagine, this issue will be popping up in various places. But if you practice in the Ninth Circuit states, such as California, this is a very important ruling. Now, I will add as a side note that if you are an NLRB practitioner, you probably should know that if you lose a case, you do have a right of review, not only in the Ninth Circuit, if that is your home circuit, but also to the DC Circuit. That is statutory. So sometimes that is a strategic consideration that you may want to keep in mind. So some pending cases of interest that you should be aware of. Stericycle is a case currently pending at NLRB dealing with employee handbooks and workplace rules. What level of control is an employer going to have? Certainly, handbooks and rules are challenged a lot in the name of protecting employee rights from either things that would prevent protected activity or chill protected activity. So this will be important when Stericycle comes out. There was a ruling of the Trump board in the Boeing company, which set the current legal standard for what employers are allowed to do in implementing rules. So I'm expecting that Boeing will likely be overruled or modified. The Atlanta Opera case is important on the issue of whether someone is an employee or an independent contractor. This is an extension of the misclassification issue that we often see in wage and hour, benefits, workers' comp, payroll tax, you name it. It comes up all over. It also comes up under labor law to determine whether someone is an employee with Section 7 rights, the ability to unionize or engage in protected concerted activity. The Amazon Services case, this is out of NLRB's Brooklyn office, Region 29, on whether employers can hold mandatory captive audience meetings. Now, for decades, employers have been able to hold mandatory meetings with employees on union-related topics, so long as they don't threaten, intimidate, or say other unlawful things. They're allowed to express opinions, facts, experiences dealing with unions. But the current general counsel has said we don't want employers holding mandatory meetings, and that's been a tough one. How do employers handle meetings that they're required to have? How do they raise labor topics if NLRB is going to challenge that? Is that a risk that many employers are willing to take if they're dealing with labor issues or an organizing campaign? So in the Amazon case, NLRB was challenging the employer's mandatory meeting, and the NLRB prosecution failed on this issue. So we'll see how NLRB continues to pursue this desired change in the law. And there's litigation out there apparently also trying to challenge the NLRB's general counsel on whether or not mandatory meetings can be restricted. So this is a developing issue you should track carefully if you are dealing with these issues. Either your client wants to hold mandatory meetings or you are advising or representing employees or unions. Pay close attention to that. Black Lives Matter is an issue which has come up at NLRB in the context of dress codes and masks and employees wearing such material at work, perhaps because they believe there's discrimination in their workplace or because there's a social justice issue that ties into what they think is going on at their workplace or an issue that they want to raise. So there's been an interesting development of dialogue on the interplay between social justice and protected activity under the National Labor Relations Act. And so there are cases being litigated right now dealing with that interplay and to see whether employers who are trying to restrict such insignia, such logos, such messaging in customer areas or elsewhere in their workplace, whether they are acting lawfully under the National Labor Relations Act. Starbucks has been the focus of a lot of activity. So has Amazon, Apple, Google, many large employers which have put labor law on the front lines in the media. And so NLRB was seeking a national injunction on terminations at Starbucks locations. They did get an injunction, and that was later scaled back to just an individual location. So we will continue to see how these issues develop. But as you might imagine, when it's not simply factories and industrial settings where labor law issues are popping up, and it's the places where people go every day, like Starbucks, or businesses that people shop on every day, like Amazon, it's going to generate more interest in this field. So I mentioned remedies expanding, the Thrive ruling, and one other angle on this. You should check out the General Counsel memoranda, which are available on the nlrb.gov website. In fact, right before I started recording this webinar, there was a brand new memorandum that came out about the General Counsel and theories that she wants to pursue. So you might want to check that out. It's changing almost daily sometimes. There was a ruling years ago in a case called Hoffman Plastics, an NLRB case dating back to when I worked at NLRB, and it went all the way up to the U.S. Supreme Court. And in a ruling from 2002, the Supreme Court said that undocumented workers may not be entitled to all the remedies to which other employees might be entitled when there is an unfair labor practice. A lot depends on the details. That's been a very controversial ruling for years, which NLRB was never happy about. The current administration certainly is not happy about it, and the agency is taking steps to protect immigrant workers despite the limitations on remedies in that Hoffman Plastics case. Just very quickly, in the realm of regulations, NLRB is looking at new regulations on representation or election cases, joint employer status, in other words, binding companies together for purposes of bargaining or liability, and some unique representation issues in the construction industry, things that I've actually been litigating about quite a bit over the years. And it's possible that other areas may see attention through regulations, but historically, NLRB has relied on case precedent rather than regulations to change the applicable rule of law. And we talked about a case earlier where there were some challenges to an NLRB representation case regulation, and it's important to remember anytime you're dealing with administrative action that the Administrative Procedures Act comes into play many times with that to assess the appropriateness of agency action. There is legislation pending on Capitol Hill. There are proposals from different parties. The most prominent one that people are aware of is the Protecting the Right to Organize, or PRO Act. which seeks a significant overhaul of federal labor law. It would largely dispense with the election process. Elections would still be there, but it would be possible for a union under this legislation to become the representative of a group of employees simply with signed cards saying that employees want the union to represent them. Employers have expressed concern about that. The ABC test for independent contractor status would become federal law rather than state law, and many other different changes. So we'll see what happens. A lot depends on not only who is president, but the composition in the House and the Senate. So query whether that legislation in current form will progress. And we'll see a lot of changes in the rules depending on, not only how legislation fares, but if it's not moving forward, you can expect usually to see other things such as executive orders or agency action that might impact certain rules and how they are applied. So NLRB is in an interesting moment. They've been reaching out to other agencies at the same time. They've been struggling to maintain their budget, which has in some ways slowed them down in terms of pursuing their agenda. But they are taking steps to help employees, the immigrant workers, secure work authorization to in their view, protect their rights under labor law and enable enforcement of the law on a more equivalent standard with other workers. They are looking at algorithm issues in the workplace to see whether productivity standards and so forth violate the law. They are looking at challenging non-compete clauses. There are issues at NLRB involving the use of pronouns, a very significant concern these days, and something where employees express themselves and band together over different workplace issues. This is one likely to raise issues NLRB addresses. So it's important that we expect labor law to apply to new and non-traditional circumstances as the workplace continues to change. So in wrapping up here, even though union density has been somewhat in decline, in other words, the percentage of employees who are union represented, we have a very vocally pro-union administration right now in Washington, D.C., and NLRB federal law is driven by Washington, D.C. politics. And the cause for change is really part of that transition from one administration to another. I mentioned that case rulings are the engine for changing the law, and litigation is going to be really what drives those changes. If you don't like the outcome, you need to look at your appeals into federal circuit courts of appeals. And again, if legislation on Capitol Hill does not advance, look for case decisions, regulations, internal policy to try to move the ball where legislation is not moving. Actually, we don't have time for questions and answers, but I have that slide anyway because I think all questions are good questions on these issues. This is an area which continues to change, and certainly that's job security for lawyers in this field. That's my contact information. I really appreciate you watching and listening to this webinar, and this has been a fascinating area of practice for me for many years. And if you are doing labor and employment on a regular basis, I encourage you to pay attention to what's going on at NLRB. Being familiar with these rules and what the agency does can be very helpful to you, regardless of who you represent, to, I think, have a more holistic view of how the workplace is regulated. Thank you.